Now we have to ask Lord Mansfield, the inventor of the constructive conditions, because the terms of our bargain no longer fix this matter. And Mansfield would say, look to the physical order. Are performances of both buyer and seller capable of being rendered at the same time and in the same place? Surely they are. Then you would be forced to tender the residual $100,000 on June the 1st. And your manifestation on June the 1st that you were ready, willing, and able to hand over the $100,000, which was the residual of the purchase price, would mature my liability to hand you a warranty deed to Scrub Oak Manor. Now you say, this is pretty baroque doctrine, and I agree. But if you work with the facts of a bar exam question, it will invariably lead you to the areas you must discuss. If the facts tell you that an immediate cause of action is asserted by the aggrieved party, then of course all discussion of repentance and suspension, etc., is placed aside. If the facts tell you that the aggrieved party reacts by attempting to affirm the transaction, you will immediately be alert to the notion that they will introduce the notion of repentance. But look to the facts to see if they do. Because it's possible, of course, that you could affirm and I could say nothing, and come the 1st of June, you would not have had to perform, because all of your covenants now, one by one, would have gone from the state of suspension to the state of discharge. The covenants having been discharged, your conditions would be excused. The effect of a breach of contract by anticipatory repudiation. What about voluntary disablement? This is an extraordinarily important doctrine, and it is unfortunate that several leading contract case books do not treat it. It goes back to the statement made to you before you were 10 years old, when somebody drew you aside and said that in this life actions speak louder than words. Let me show you how the breach could occur and what its consequences could be, and we can use the identical factual pattern so as to reduce the burden on you of taking notes. Same deal. Same deal. Okay? Now, having entered this contract on the 10th of January, we're looking forward to removing yourself to Davis, becoming the laird of Scrub Oak Manor. We have certain social obligations in that small, befuddled community. And so you take out a subscription to the local newspaper so that you can begin to understand your new home. That newspaper is called the Davis Enterprise. It is also the legal newspaper for the county in which Davis, California, is situate. It is a daily newspaper publishing every day of the week, save for Saturday. And you are receiving the Davis Enterprise on a daily basis. And it is now the 20th of the month, and you're reading your very favorite part of the Davis Enterprise, the legal notices. And you see a notice from the county recorder of deeds, noting that a deed has been recorded in which Dan Fessler is listed as the grantor, and James Edward Hogan as the grantee. And the summary description in the legal notice is indisputably Scrub Oak Manor. Is that a breach on my part by anticipatory repudiation? It could never be. I have not communicated with you at all. Remember, anticipatory repudiation requires the communication of a definite, defiant, unyielding renunciation. I haven't said a word to you. But what is the consequence of your having gained credible information that subsequent to the formation of our contract, I have taken a voluntary step which places performance on my part of the obligation under our contract beyond my power or control? That is regarded as a breach by voluntary disablement. What was the breach? Not the legal notice, the conveyance to Hogan on the 17th of January. The moment I conveyed title of Scrub Oak Manor to Hogan, I breached the contract with you via the machinery of voluntary disablement. What are the consequences of a breach by voluntary disablement? In the majority of jurisdictions, you are required to bring an immediate cause of action. Right? In all jurisdictions, you are given that option. My voluntary disablement accelerates what had been a future conditional obligation on the 1st of June to the date on which I conveyed the title disabling me to Hogan. On that day, I was regarded as having a present, unconditional, fully matured obligation to convey the title to you. When I didn't do it, I am in present material breach of the contract. All of your covenants, your promises of payment are discharged. As conditions precedent to my liability, they are each and every one excused. You could bring an action against me for $50,000, seeking to recover as a loss of bargain the difference between the contract price and the market value of Scrub Oak Manor as established in my sale to Hogan for $550. You would never be called upon to demonstrate that you could have paid any of this money. Your covenants are discharged. Now, in those jurisdictions that would allow you to await the performance date, the majority of them would not allow me to reinstate the terms of the contract by effectively reacquiring the title from Hogan. That's why actions speak louder than words. If I break the contract via the machinery of voluntary disablement, it is busted, period. And I cannot put Humpty back together again. In the very small minority of jurisdictions, and I say this only to reduce the level of anxiety to somebody who may have been taught that there is a doctrine of repentance allowed, in those jurisdictions it works just like a repentance of an anticipatory repudiation. But on the California bar, we don't do minority and majority rules. And so the easiest way to prepare for the bar is with the maxim, actions speak louder than words. If the breach is via the machinery of voluntary disablement, our contract is broken, and you have an immediate cause of action against me. All of your covenants discharged, all of your conditions excused. Those are the two common law doctrines. The seen in this context, if you'll work with the facts, they are eminently reasonable in terms of the subject matter for a bar exam question. You will get the full credit by simply scrupulously paying attention to the factual development. Now, I said there was a third doctrine, one that obtained only under the Uniform Commercial Code at the present time. That was a breach of contract by a failure to give or provide adequate assurances of performance. You can see the need for this doctrine and have a better chance of understanding how it works if you will appreciate the following possibility. Suppose that, having entered the contract to sell you my home, Scrub Oak Manor in Davis, I had sent you a telegram saying that I had received a $50,000 better offer from Jim Hogan, and I was giving serious thought to conveying Scrub Oak Manor to him. Another variation. You read the daily newspaper from Davis, the Enterprise, and on the 20th of January, you read not a notice from the Recorder of Deeds, but from the clerk of the Superior Court. And you discover that I am listed as a defendant in an action brought by my colleague Jim Hogan asserting a cloud on the title of Scrub Oak Manor. Either the telegram that says I'm giving serious thought to selling to another, or the legal notice that Scrub Oak Manor is now about to be tied up in litigation, will excite serious anxiety in your mind as a person who's being called upon to part with $500,000 in cash in less than 6 months. And yet your prospective seller is obviously having second thoughts in the case of the telegram about Hogan, having big difficulties in the case of the notice that he's tied up in litigation. But you see, the telegram wasn't a breach by anticipatory repudiation. Oh, there was indeed the communication, but it didn't have about it the definite, defiant, unyielding renunciation. I just said I was thinking about it. The legal notice could not be a breach by voluntary disablement unless you could prove that I had taken a step subsequent to the 10th of January that caused the cloud. Under the common law, you have to put your anxieties aside, get your money out, and take a $500,000 trip to discover whether or not I will, on the 1st of June, be able to convey the deed in a warranty manner, free and clear of all encumbrances. See, that's tough. It is. It is precisely for that reason that the Uniform Commercial Code says that if you enter into a transaction with a merchant, almost always it's a merchant seller, and subsequent to the formation, you develop reasonable insecurity regarding the prospective ability or willingness of the merchant to perform, then you may make what is called a written demand for adequate assurances of performance. And unless the merchant upon whom you have made this written demand reacts within a commercially reasonable time to give you adequate assurances, you may treat his failure to do so as a present breach of the contract. So under the Uniform Commercial Code, you have a far more palatable alternative to marching forward with your own performance, though you are gravely anxious. Now remember that you must be under what is called reasonable insecurity. This doctrine is not intended to protect Chicken Little. Right? The insecurity must be a reasonable one. And if that should ever be disputed in litigation, if you are the one who sought to invoke this machinery of adequate assurances, you'd have to prove that you were acting reasonably. Assuming that you act upon your insecurity and that's reasonable, please notice that you must make your demand in writing. An oral demand, a demand on the telephone, doesn't set this machinery in operation. If you make the written demand, the moment you have made your written demand, all of your performance obligations, both as covenants and conditions, are suspended while you await the response of the other party. If you never receive the adequate assurances, then any conditions that have protected the merchant are excused. And upon the expiration of the reasonable period for the giving of assurance, she is in present material breach of the contract. Your covenants are all discharged. The conditions all excused. Notice that the code doesn't set a date, say 5 days, 10 days. It says that there must be a response within a reasonable time. If the merchant upon whom you have made the written demand for adequate assurance responds within a reasonable time, the next issue is, has he given you adequate assurances? Again, they love to ask this question on the bar because it involves recognizing that that's an issue and you have to discuss it. The easiest way to do it is to look to what it was that gave you the insecurity and then compare that with the explanation or promises or representations being made in the assurances and ask, would a reasonable person now feel assured? If the answer is yes, then the deal is on. And all the suspended terms of the all of the suspended terms of the contract are revived, both as conditions and as covenants. And so, my friends, we've exhausted now the topic of excuse of conditions. And we have treated the matter of the fourth of 6 possible issues of contract law. Have the contract duties matured? Meaning that they either were never conditional, they were independent promises, or if they were dependent in nature, that the conditions have either been satisfied or they have been excused. We now come to the fifth, and for what is us, the briefest visitation to a major issue of contract law, the doctrine of excusable non-performance. And here I have an apology to make for the terminology in my field. We have been speaking for the last 20 minutes of excuse of conditions. We are now speaking of excusable non-performance. Right? The old common law doctrine, which labeled this topic discharge, which now sounds like toxic waste, is probably therefore more useful, because we excuse conditions, but under 3 modern doctrines, the refusal of a party to perform what is otherwise a fully matured contract promise may be a matter of legal privilege. If it has been discharged or excused on a theory of impossibility, impracticability, or frustration. Those are the three doctrines. Let's briefly highlight them. The first is called objective impossibility. If subsequent to the formation of the bargain, either physical or legal barriers arise so as to render the obligor's promised performance objectively impossible, such an obligor is excused by operation of law. The critical factor is that the performance must be objectively impossible. What does that mean? It means that given the circumstances as they have changed subsequent to the formation of the bargain, not only must the promisor be unable to perform, but there must be no person on the face of the earth who could carry out the terms of the promisor's obligation. Objective impossibility. If the only consequence of the after arising barriers are that I cannot perform, though another person with greater capacity could, that is called subjective impossibility and is no excuse at all. No excuse at all. What would be an example of an obligation which has become objectively impossible? Well, we remember that at the beginning of our session today, we met an individual by the name of Fox, and I told you that he was a house painter by profession. Suppose he had agreed to paint the interior of Brown's house, and he's midway through the work, and without fault of either party, Brown's residence is destroyed by fire. This destruction would discharge the obligation of Fox to do the painting. Not only could Fox not paint what is now a pile of rubble, but there is no one on the face of the earth who can give a pile of ashes a coat of paint. Objective impossibility. What about commercial impracticability? If the essence of objective impossibility is physics, and the barriers that physics present, commercial impracticability has as its essence economics. It is said that a thing is impracticable when it cannot be accomplished except by an expenditure grossly disproportionate to the agreed upon exchange. So I'm not claiming that I can't do it. I'm claiming that to do it would now cost me so much more than either you or I anticipated at the formation date. It is intrinsically unfair to hold me to my promise. But the law does place a premium on planning, and thus in order to claim an excuse premised upon the doctrine of commercial impracticability, it will be necessary for me to show that the factors which have arisen subsequent to formation were not foreseen by either you or me at the formation stage. Indeed, the old common law went further. It said that the after arising factors must not only have been unforeseen by these particular parties, but they must have been unforeseeable to a reasonable person as well. The Uniform Commercial Code has relaxed and made more readily available the doctrine of excuse premised upon commercial impracticability. It is sufficient if I can prove that at the formation stage neither you nor I anticipated these after arising factors. And then all I have to do is show that these after arising circumstances have cast upon me items of cost which are wholly disproportionate to what we had assumed, and I'm free, legally privileged, not to perform. The final doctrine of excusable non-performance is called frustration of purpose. It is the most subtle by far. It does not involve a claim that performance is physically impossible, or legally impossible, or even economically impracticable. The gist of a claim of frustration of purpose is that subsequent to the formation of our bargain, circumstances have so dramatically changed that your performance is no longer of any value or utility to me. I now ask to be excused from having to perform my promise to you, claiming frustration. Frustration. Now, a few years ago, when I was working out these doctrines to include them because they are important for the bar examination, I was attempting to explain this to my daughter, who was then 8. And she sat and patiently listened. And when she was done, she said, "I think I have it. I think I know what you tried to say. If it's impossible, it can't be done. If it's impractical, it now costs too much to do it. If it's frustrated, it's no longer worth the original cost. Someday when I'm old and gray, that child may be supporting me." And that is the doctrine of excusable non-performance. Well, ladies and gentlemen, there had to come a point when we reached the 6th issue, and we've reached it. We are facing now in the fact pattern a breach, a garden variety breach of contract. Nothing dramatic like anticipatory repudiation or voluntary disablement. Nothing new and fancy such as a failure to give adequate assurances of performance in the face of a timely and reasonable demand. Simply the idea that a party to a contract who had a fully matured obligation has either failed to perform, has refused to perform, or has defectively performed. Now, in the face of breach, there are 2 critical things that I suggest be the components of your approach. And the first is where people are losing points all over the bar exam. Faced with a breach of the contract, I want you to first canvass in your mind what is the impact of that breach upon the affirmative duties of the aggrieved party. Right? The second is the point that we're all rushing to get to, and that is the discussion of remedies. But let's take the approach one step at a time. Before you can work with either of these topics, the affirmative obligations of the aggrieved parties or the remedial rights that accrue to the aggrieved party, you must first do a very, very major analysis with respect to the breach as either being material, going to the very essence of the expectation of the aggrieved party, or being merely minor. Right? Now that's probably the single most important value judgment that you must make and defend on the exam if it's an essay, or carefully watch the facts to determine if you are selecting alternatives on the multi-state. All right? Now again, let me state the difference. The breach will either be material or it will be minor. If it is material, it will have gone to the very essence of the bargain. Right? If it is minor, it has impaired the bargain only in some insignificant sense with respect to quality or quantity, or in some inconsequential manner with respect to time. Now, how do you set this up on the essay question? Well, I suggest that the first thing you do when faced with a breach fact pattern is to write out in 2 or 3 sentences, surely no more, what appear to be the commercially reasonable expectations of the aggrieved party arising out of this bargain. Next, state what appear to be the consequences of the breach. And then it's very simple to draw the conclusion that the consequences of the breach have pretty well destroyed those expectations, or it will be evident that they have not. And you have reached your conclusion that the breach was minor or material. Now, what follows upon that distinction? If the breach is material, then the contract is dead for all purposes other than ascertaining an appropriate remedy. Right? So if the breach is material, the aggrieved party has an immediate cause of action for a loss of bargain remedy at law. An amount of money, insofar as damages can approximate it, aimed to put her in the position he would have been occupying had there been full performance and not breach. If that cannot be done, then the aggrieved party has standing to sue in equity. All right? If the breach is material, because the contract is dead, the aggrieved party must immediately forego all further effort to perform his own contract duties. They will never be performed. And he embarks now upon a new course of behavior designed to mitigate his damages. So he abandons the contract in the face of a material breach, seeks to mitigate his damages, and turns to remedies. How radically different if the breach is only minor in its dimension. If the breach is minor only, the aggrieved party must go forward and perform her own contract duties, while looking to the damage remedy at law to eventually make her whole for any loss which she can prove. And of course, the most tragic thing in the world is an aggrieved party who mistakenly judges the breach of the other trader to be material when in hindsight it is deemed to be minor. If I mistakenly brand your breach of contract material and I abandon the contract, there will be somebody in material breach. Me. And so that rule causes us to err on the conservative side of being very certain the breach is material before we take this dramatic step of abandoning the contract for all purposes other than mitigating our damages and seeking an appropriate remedy. Now, from this point on, I want to talk about the affirmative duties of the aggrieved party. Okay? Again, especially those that are devised under the Uniform Commercial Code are within the fair ambit of the materials on the multi-state examination. They can show up on the essay exam. They are not covered well in certain contracts case books. They are very well detailed in the PMBR written materials, but let's start with the generic concept. The affirmative obligation of an aggrieved party faced with a material breach, and from this point on we will assume all breaches are material, is to abandon all effort to perform the contract. That was the common law doctrine. And embark upon a new course of behavior designed to mitigate damages, avoid any avoidable elements of loss. And that common law rule is the one you will use if the subject matter does not fall within Article 2 of the Uniform Commercial Code. It is particularly apt to use if the contract is for the rendition, let us say, of personal services. Indeed, if the subject matter is unique, it may be that it's almost impossible to mitigate damages, because there's simply nothing that I can do. So that if this is not a complicated topic at common law, the complication arises if the contract was for the purchase and sale of goods, right? And it's governed by Article 2 of the Uniform Commercial Code. We're going to use a hypothetical now to work through these affirmative duties of the aggrieved party. It is the one we had last hour. We have a contract between a seller and a buyer. Both are merchants. The subject matter of their contract, 100,000 cases, navel oranges. The contract price, $3 per case. Under the terms of the contract, the seller is to deliver the goods at the buyer's warehouse on or before the 10th of June. That is the executory bilateral contract they form in the last week of May. I want you to assume that on the morning of June 8th, the seller places in motion 3 large trucks loaded with 100,000 cases, each case labeled as containing navel oranges. That afternoon, they arrive at the buyer's place of business. That amounts to a tender by the seller. faced with a tender of performance by the seller, what is the first affirmative duty of the buyer? Under the Uniform Commercial Code, it is to inspect the goods for conformity. It is a duty in the sense that the code says that the buyer must conduct a prompt inspection of the goods tendered by the seller. What happens if the buyer does not promptly inspect the goods? Then the goods have been received and they are to be paid for at the contract price, no matter what is in those boxes. Pretty dramatic. That's why it's a duty. I must go out and make a prompt inspection. What's prompt? The code doesn't say. It would be governed by the nature of the subject matter. Here, perishable food would suggest that prompt is quick, as well as the customs and mores of the marketplace. Let us suppose that on the morning of June 9th, the buyer has inspected the goods and finds that while 99,900 cases contain goods conforming to the contract description, navel oranges, 100 cases were mislabeled and upon inspection proved to contain lemons, not conforming to the contract description. All right? And so on June the 9th, there's an inspection and nonconformity is discovered. What is the next affirmative obligation of the buyer, who is now for the first time being called an aggrieved buyer? She didn't get what she ordered. Right? She is to give prompt and specific notice to the seller of the alleged nonconformity. Failure to give prompt and specific notification to the seller amounts to a waiver of the nonconformity, leading to the conclusion that the buyer is obligated to pay for the goods as tendered at the contract price. Well, suppose that having gone through the duty to conduct a prompt inspection and having ascertained nonconformity, on the afternoon of June 9th, a prompt and specific notice is given to the seller. The buyer calls the seller and says there's something wrong, and specifically, 100 cases of the goods don't conform to the contract description. They contain lemons rather than oranges. Having made the prompt and specific notice, the code says that the aggrieved seller now may take advantage of what is called the perfect tender doctrine, the perfect tender rule. That permits the seller to reject the buyer's tender of the goods for any non-conformity. Right? For any non-conformity. Under the perfect tender doctrine, the seller now has an election as among three alternatives. First, she may reject all of the goods, both the conforming oranges and the non-conforming lemons. Second, she may elect to accept the goods that conform to the contract description, while limiting her rejection to the non-conforming lemons. Third, and you will be astonished as to how often your clients will choose from column 3, the aggrieved seller may elect to waive the nonconformity and to accept the tender as is with knowledge of the nonconformity. Right? Since the last thing most merchants desire to do is litigate, it is not at all uncommon for parties to engage in the third alternative, acceptance of the tender as is. Again, facts are going to tell you on the exam what's going on if you'll simply follow them. If I reject all of the goods, we'll see in a moment what happens. Suppose I limit my rejection merely to the non-conforming lemons, I then must immediately pay you for the goods I have accepted at the contract price. If I elect to take all of the goods with knowledge of the nonconformity, I pay you at the contract price, treating the lemons as if they were oranges. Treating the lemons as if they were oranges. So the third step on June 9th, we've had inspection, prompt and specific notice, election under doctrine of perfect tender. But, and here's where it's so important to look at the facts, but the original term of the contract had given the seller until the 10th of June. It just so happens that the seller tendered his performance 2 days ahead of that deadline on the 8th. Notwithstanding an election to reject goods under the perfect tender doctrine, if time remains for the seller's performance under the terms of the contract, then the next affirmative duty of the aggrieved buyer is to cooperate in any cure, C-U-R-E, effort on the part of the seller. This is probably the single most ingenious breakthrough of Article 2. After centuries of litigating these disputes, we finally figured out that no court ever produced an orange. The only institution in society that can heal the rift in this arrangement is the marketplace, not the courthouse. And the individual most likely to be interested in healing the rift in the transaction is the other party to the transaction. Therefore, if any time remains, and under our fact pattern, 24 full hours remain, if, when given the prompt and specific notice in the morning of June the 9th of the nonconformity, the seller responds by announcing an intention to cure the matter by replacing or arranging to replace the non-conforming lemons with conforming oranges, then it is the affirmative obligation of the aggrieved buyer to cooperate in that effort. And if during the period of time allowed, the seller manages to replace the non-conforming lemons with oranges, then it is academic as to whether anyone was ever in breach, because the breach has now been healed in the marketplace, and it becomes the obligation of the buyer to pay the full contract price, and everyone lives happily ever after. Even more extraordinary, if the buyer notifies the seller of nonconformity, and the seller reacts in good faith, not by pretending, but in good faith by claiming surprise. The seller is surprised that his goods were nonconforming. In our hypothetical, you call me up as the buyer and say, Fessler, I don't know how it happened, but although you've got goods labeled oranges, they contain lemons. I say, I don't either. I have been buying citrus fruit from the same ranchers in the San Joaquin Valley. And that's true, friends. I did say ranchers. In California, we ranch oranges and lemons and grapes and things of this nature, whatever may be done elsewhere. The same ranchers, and I've never had mislabeled fruit. That happens to be a seller who in good faith is claiming surprise. Then the code's interest in using the marketplace to heal this rift requires, as part of the affirmative duty to cooperate in a cure effort, that the buyer grant the seller a reasonable extension of time. If the seller says, gee, if you'd give me another half day, I can get replacement goods to you from my warehouse in Fresno. You'd have to give that extension of time unless, of course, the seller can demonstrate, the buyer can demonstrate that would prejudice her own commercial interests. She's supposed to cooperate, but that doesn't mean she's supposed to sacrifice her own commercial interests to those of the potentially defaulting buyer. But you see here, I've already got 99.9% of the goods. It would be very unlikely that granting the seller an additional half day to replace the non-conforming lemons with oranges is going to be prejudicial to the aggrieved buyer's interest. And so there would be the obligation to grant the extension of time. If the goods are replaced within the extended time period, again, it's academic as to whether there was ever a breach. It's been healed in the marketplace. I now go forward and as the aggrieved seller who has now received all the goods I wanted from the buyer, I pay him the contract price and go about my business. Right? So we've now talked about the affirmative obligations, that is, the prompt inspection to ascertain conformity. In the event of a discovery of nonconformity, the specific prompt notice to the other trader. The election under the perfect tender doctrine. Observing the duty to cooperate in a cure effort, which is an absolute duty if time remains. A duty that I must undertake unless I can demonstrate prejudice to my own commercial interests if a requested extension of time is made. Suppose, however, that I call as the buyer, the seller, on the afternoon of on the morning of June 9th, and I tell him of the nonconformity, and he makes no indication of an intention to cure, or says something to me that is unspeakably rude. Well, if it is clear that there is not going to be any cure obtained from the defaulting seller, for the first time now, the seller is definitely in breach of the contract, all right? No cure, non-conforming goods equals breach under the UCC. Now, what are the affirmative obligations of a person whom we can begin to truly call the aggrieved buyer? Okay? Well, they're startling the first time you hear about them. The first affirmative obligation I have is to follow any instructions of the defaulting seller with regard to the disposition of the goods that I am rejecting under the perfect tender doctrine. So I must ask the seller what I am to do with those goods that I am rejecting. And I must, at my own expense, follow any reasonable instructions. Therefore, if he tells me to place the goods that I am rejecting in cold storage in a facility designated here in the Los Angeles area, at my own expense, don't worry, I'll be compensated in a moment, but at my own expense, I must now follow those instructions. Suppose that I seek instructions and he refuses to give them. Now what is my affirmative obligation?